Thank you, Mr. Chairman. Let me start by drawing a distinction that I think is important as we consider this. There are applications, there are transactions one could contemplate, transactions we've seen that involve tokens of crypto projects. The transaction which any reasonable person would say that looks like a security and therefore comes under the regulatory purview of securities. That, however, is very distinct from saying that the token itself is a security. So, for instance, you could imagine a transaction. Let's take something that I think there's universal agreement. Gold is not a security. Gold is a metal, and it's a commodity under American law. But you could use gold in a transaction that the SEC would certainly have jurisdiction over. If, for instance, someone were to make an investment vehicle, the repayment of which was denominated in gold bullion, the transaction would be a security. It'd be regulated by the SEC. But it wouldn't turn gold into a security. Gold would still be a commodity. Now, in the last several weeks, we've seen the sensational and terrible cases where companies whose crypto lending services, the activity regarding these tokens, were very arguably within the SEC's purview, and they collapsed. Sensational collapse. Firms were offering interest rates as high as 18% if customers would lend the company their digital assets. Firms, as I mentioned earlier, would then take that crypto, lend it to presumably larger investors who were speculating in the crypto markets. And one of these firms, Celsius, reportedly had nearly $12 billion under management. This is not small. And when the wheels came off and it all collapsed, the customers' funds have been frozen since mid-June, leaving in serious jeopardy the status of billions of dollars of deposits that, frankly, I think many people will not get back everything that they lent. So we have this activity that certainly looks like it's securities activity. The SEC, though, did nothing. They failed to act before Celsius went bankrupt. And that's despite there's press reports that indicate as early as January of this year, the SEC was investigating whether this particular firm was in compliance with securities law. It's under investigation. 6 months later, nothing happens and the firm blows up. Now, I realize that in the face of SEC inaction, a number of states did take action. Securities regulators in various states did take action specifically against Celsius with cease and desist orders that go back as far as last September. I understand Maryland did not. And I wonder if part of that is because really this should have been the responsibility of the SEC to deal with this. So, Ms. Lubin, let me just ask you, do you think that a crypto lending product falls under the jurisdiction of the SEC?
Thank you, Senator, for that question. The state securities regulators have overlapping jurisdiction with the Securities and Exchange Commission over many, many things. And one of those things includes different types of securities. And depending on the type of security it is, will depend on what the requirements are at the federal level and then at the state level. At both the federal and the state level, I believe that these products are securities. We have very similar definitions, and the list within our statutes of how securities are defined are very similar.
So this falls. So you just answered the question that this falls under the SEC's jurisdiction. It falls under the state securities jurisdiction. Unfortunately, no clarity was provided about what constitutes a security, which might have dissuaded people from making the investment in the first place. Who knows how things might have been different if we had had clarity about this. By the way, you may be aware of the SEC's action against BlockFi. It was taking an action for very similar activity. So clearly the SEC had a theory about why this constitutes a security, but yet they never disclose that. They don't share this information with us. Let me move on because I'm running out of time. On the question of the token itself, right, as opposed to a transaction involving a token, let's talk about the token itself. Chairman Gensler has expressed the view that most digital assets are securities. I think he said virtually all of them are actually securities themselves. But once again, he has refused to respond to calls for clarity as to why he comes to that conclusion. And I think there are a lot of good reasons to be very skeptical about the logic. Among those reasons is that a token that's associated with a distributed ledger technology is lacking features that we commonly associate with securities. So for instance, let's look at the Howey test. I went through the 4 criteria of the Howey test. One of the things that a token very seldom has is a specific claim for any return or a specific claim on the income of a project or an enterprise, any specific claim on the assets, right? There's no such thing. But yet, those features, I think, are universal among securities. So in the absence of a commitment by an issuer to provide a return, in the absence of any kind of claim of ownership or assets or anything about the issuer, how does the token meet the Howey test's expectation of profits prong, or even the investment in a common enterprise, if there's no claim on that enterprise?
Senator, thank you for raising that issue. I think when you evaluate a product as to whether or not it's a security under the Howey test, it's the expectation of profits, but the expectation of profits can be the appreciation and the value of the token. So if somebody is purchasing that from a promoter and they expect there to be an appreciation of value, that can meet the expectation of profits requirement.
Except that there's no guarantee of that. There's no claim on the issuer. Can you think of a security that we all acknowledge as a security prior to crypto where there's no claim on the issuer in any form?
I think there are a lot of different types of tokens out there, and you really need to evaluate each one on a case-by-case basis.
Fair enough. And if there's a token out there that does say offer a percentage of profits of the enterprise, or it offers a particular return, then that starts to look a lot like a security. But you're making my point for me. There are different kinds of tokens. They are different from what we have always considered securities to be, and it would be really helpful to have some clarity in this space, and we have none. And that's why, frankly, I think we need to legislate on that, because this is a new category of asset that does not look like all previous categories of assets. And it's a failure of Congress to provide that clarity, and it's a failure of the SEC not to at least provide the clarity of their interpretation, which, by the way, is controversial, is not shared by, say, the CFTC, is not shared by bipartisan folks on the Ag Committee. So I think I see I'm out of time, but I think we need that clarity. I'm sorry I run over. I think Senator Cortez Masto is next.
Thank you.